Hello, my name is Brett Bendistis, and this is a video lecture on multi-issue IRACs. We're going to talk a little bit about IRACing a problem that has a lot of elements to it. When I talk about multi-issue IRACs, I really want to kind of have this idea of a broad question that has a lot of individual parts to it that need to be addressed in kind. The thing about an IRAC is we're having this issue, rule, application, conclusion. You start by saying what the problem is. Rule, you sort of layer the law in a way that's reflected with this slide here, where we're talking about a broad statement of the law. Practical ways to prove the law, like standards of proof, burdens of proof, what elements are really established. It's where you sort of describe cases. And then you go back and then do the application section, where you're applying the law to the rules. One of the key things about any legal conclusion that you should have is that you want to make sure that you're always incorporating as many rules as possible and as many facts as possible. The difference between a legal answer and, let's say, a medical answer is that the law is everything. You never want to sort of just say, well, this is the answer, it's ABC. This case is applicable, so therefore we win. I've always found that the most successful legal arguments I've made is when I'm able to isolate the important elements and very clearly, succinctly give my answer over and over and over again. And this is sort of where I want to bring in the tangent that I've titled the article as, which is Bon Jovi concerts, right? Whether this is good or bad, who knows. I have had the pleasure of going to 2 Bon Jovi concerts. My first concert ever was like in 1988 at the Philadelphia Spectrum. The second one I went to, I was 20 years old at what is, I don't know what it is now, but it was like the E Center when I was 20. Right? So it's the big thing in New Jersey and Camden where they have concerts, right? So what I'm bringing up here is that when I went to this Bon Jovi concert, the second one in specifics, my favorite Bon Jovi song, like, I don't know, everyone's favorite Bon Jovi song is Living on a Prayer, right? Everybody loves Living on a Prayer. It's his best song. So I get in there slightly late and missed Living on a Prayer. It's the second song he played. And that is insane to me. It still blows me away that you would play your best song first. You wouldn't bring it up again. I mean, he should be playing Living on a Prayer in the middle of the set, the end of the set, and hey, let's just throw it in as the encore. It's your best song. I would like you to approach this multi-issue IRAC the same way that I would wish Bon Jovi would approach his concerts. Tell me the answer over and over again. Affirm why you are right constantly. And that idea of saying something over and over again, I think, for non-lawyers seems strange. Why am I saying this? This is wasted time. But the part of the multi-issue IRAC that I think is important here is you want to constantly direct the reader where you are going at all times. Your issue should serve as a topic sentence. Your conclusion should serve as like rounding it up. Everything should always be related in a way where you are letting the person know where to go. A hypothetical of where I'm kind of going with this is in regard to both Tonya Harding, if you remember that story, and the elements of conspiracy, a very specific criminal statute that is applied in every jurisdiction. It's in federal law, it's in state law, but it's got a few elements, and I think it represents this problem well. Now, Tonya Harding is a world-famous Olympian from, I don't know, the early 90s, who was accused of organizing with her husband and some, like, henchmen to assault her biggest rival. The idea would be that if they took out the rival, she would be more likely to get the gold medal. Right? There's a million different stories about this. She denies her involvement in the incident, but everyone else is like, no, she was clearly involved here. And where her fact pattern fits within the law is in the elements of conspiracy, the thing I mentioned before. Now, conspiracy is a crime that punishes just thinking of planning a crime, right? Like if you have a plan, you're guilty, and you have to prove intent, agreement, and overt act. Those are the 3 things: that you intended to do something bad, you agreed with somebody else to do something bad, and then the overt act is you did something in furtherance of that bad thing. Now, if you were writing a rule statement based on those 3 elements, it would be so unwieldy, it would be multiple pages, because you'd have to introduce what is conspiracy. You'd then have to go into the practical proof of each element. There's a lot of stuff with conspiracy that isn't just open and shut. And then the examples of the laws in practice, I mean, you're almost giving a book report on law. That's a very ineffective way to present the issues that are here. So, the idea I want to present is an idea of giving a thesis paragraph that introduces the issue, and then separate IRACs for each element. So when we go backwards here, we're talking about 1, conspiracy. right? So something that introduces conspiracy, and then something that just covers intent, just agreement, and just an overt act. The way we start this is with something called a thesis paragraph, and it's a good way to start this broad issue that has a lot of different elements. The way that I would suggest doing this is first introducing the issue broadly. The issue here is whether Tonya Harding can be convicted of conspiracy, right? Give the broadest rule of law applicable. These are the elements of conspiracy. And then I have some law on the next couple sections that just briefly kind of introduce the issues of, hey, conspiracy is allowed to consider circumstantial evidence because we've got something else, right? What applies to everything? The state has to prove every element beyond a reasonable doubt. It's a good place to generally introduce what's the broadest issues before you get into the individual nuances. And then finally, restating your conclusion briefly. This is where your living on a prayer section comes up. The first sentence, this is the broad problem. The last sentence is, I'm about to show you why either she should be convicted or not be convicted. The difference between, again, the Bon Jovi analogy and let's say M. Night Shyamalan, right? The big Hollywood director with the big twists at the end of his movies, is if you are finding that you're not giving your conclusion to the problem until the end, I think you're doing this wrong, because you don't want to build toward a conclusion. You want to tell your conclusion and then explain it repeatedly. Make sure that the reader always knows what your answer is. That way there's no confusion about where you're going. Take a look at this issue paragraph here. Now this is also going to be posted to Blackboard. So if you, I know part of this is cut off because my head is here, but I do think that there's a good section that's able to read, right? So first, the issue is whether the state's circumstantial evidence will sustain a conviction for conspiracy against Harding. Broad introduction. Right? The elements. She's liable for conspiracy when they can prove intent, agreement, overt act. Again, right? Broad subjective nature of these elements may rely on some circumstantial evidence, covering everything. So the first section of the introductory paragraph is like, this is about what I'm going to talk to for everything, right? A similar example would be, let's say you're trying to prove personal jurisdiction. Commonly, like especially in Delaware, there's two elements. One, it's okay based on the statute. Two, it's okay based on the Constitution. Before getting into those elements, because they're so involved, introduce the fact that part of conspiracy is, part of personal jurisdiction is giving evidence, proving it at the onset. It has to be done before the answer's given. And this is sort of a way to introduce, hey, this is what's about to apply for all the elements going forward. The next sentence is, although they'll be able to prove intent, there's no evidence of a agreement or the overt act, so therefore there's a problem. So essentially, we're giving first sentence, broad introduction, then the broad law, and then just a statement of our answer, which is kind of why when you're putting this together, I will often write the kind of introductory paragraph last, because the conclusion is going to be part and parcel with the discussion we're having later on. So this is sort of how I would do the remaining paper. So that's the introduction. This would be the issue and rule for intent. So we're having the issue regarding intent is whether or not the state can prove Harding exhibited the required intent for the charge of conspiracy based on co-conspirator statements. Again, we're restarting our IRAC structure. There's the issue, and then there's the law for intent. Now, when we look at this, if we had all this law with all the other law, again, it would be a mess. So the point is, we're going to take one thing at a time. First, I'm going to deal with intent. On the other end, we start our application and conclusion paragraph by going over how the facts apply to that section. And I like to start this sentence, again, with living on a prayer, with the conclusion I want to prove. The state will likely be able to establish the element of intent in the case against Harding. So, when we go back to our first paragraph with the subsequent IRACs, the issue is regarding intent, whether they can prove it. The next first sentence, they will be able to prove it. State your conclusion over and over and over again so they know that it works. The last sentence is essentially, because of these elements, they'll be able to approve it. So it's a matter of taking the rules, taking the application, and parceling out into individual sections. It doesn't have to just be for statutes with elements to it. I find that this is a really helpful way to break out something if it's too unwieldy. If you're writing an IRAC and there's too much to it, think of the idea of generally introducing it with a short paragraph and breaking them into individualized IRAC statements that cover each individual point. Because I think if you're able to restate your conclusion as many times as possible, create a level of clarity that kind of adds to that affirms what your answer is, I think you're going to find that it's going to be more helpful, it's going to be more clear, and it's going to be more concise. That is the lecture for today. Again, my name is Brett Bendistis. If you're interested in these lectures, there are more on YouTube. You can also visit my podcast, which is the Citizen's Guide to the Supreme Court. It is over iTunes, YouTube, all kinds of other stuff. Thank you guys very much, and I appreciate you watching.